Eli Navarro thinks he's doing the responsible thing. His kid is sick, his tap water tastes like metal, and the bills keep stacking. So he sues the company on the statement, the name everyone recognizes. The court tells him he sued the wrong company, case dismissed. It should end there. But a week later, a routine insurance packet arrives, and one line doesn't make sense. It quietly links the water system to the town's biggest employer, the factory that pays everyone's rent, funds the Little League, and signs half the paychecks in Briar Glen. Eli pushes forward. He finds documents nobody was supposed to see, and when the truth finally breaks into daylight, it doesn't just threaten executives, it threatens the entire town. Because the moment Eli exposes everything, innocent people start losing everything. Briar Glen, population just under 11,000, sits in the kind of valley that looks good on a postcard. Hills on three sides, a river that used to run clear, a main street with a diner, a pharmacy, and a hardware store that's been in the same family since 1962. It's the kind of town where people wave at strangers and mean it. Eli Navarro had lived there his whole life. His daughter Maya was 7. She liked strawberry milk and refused to wear matching socks. His wife Carmen worked double shifts at the hospital 2 towns over. Eli did HVAC work. Mostly nights, mostly for the housing developments going up on the east side of town. It was a life built out of ordinary parts, and for a while it held together fine. The first sign was easy to miss. Maya started complaining about stomach aches in late fall. Not dramatic, just a quiet, persistent thing she'd mentioned before school or at dinner. Eli assumed it was stress. New teacher, new classroom. Kids carry things in their stomachs. But then the neighbors started talking. The Garcias, 3 houses down. The Petrovskis on the corner. All of them had kids or elderly parents with similar complaints: fatigue, nausea, headaches that wouldn't lift. The kind of symptoms doctors call non-specific. The kind that make you feel like you're overreacting until you're definitely not. Eli had the tap water tested through a private lab. He paid $180 out of pocket. The results came back 10 days later. Elevated levels of trichloroethylene, a solvent used in industrial cleaning and degreasing, not a trace amount, not a rounding error. He brought the results to the county health office. The woman behind the desk looked at the report, looked at him, and said there was no documented evidence of systemic contamination. She offered a coupon for bottled water through a local program. Eli took it. He didn't use it. He drove home, sat at the kitchen table while Maya did homework across from him, and made a decision that would cost him more than he could calculate at the time. He said, out loud, to no one in particular, "I'm not letting this slide." The first thing Eli did was look for a lawyer. He wasn't naive. He knew this kind of case was expensive and long and usually lost. But he'd done his homework. He'd looked up environmental contamination cases. He'd read about Hinckley, about Camp Lejeune, about a dozen smaller towns that never made the news, but whose residents still carried the damage in their bloodwork. 3 attorneys passed. One told him utilities operate through layered subsidiaries, and that naming the right defendant alone required months of corporate research. Another said the threshold for proving causation in chemical exposure cases was genuinely brutal. The third took his paperwork, called him 2 weeks later, and said the case had merit, but only if he was willing to go the distance. Eli filed suit against Briar Glen Municipal Water Services, the name on the bill. The name on the notice they'd sent 6 months ago saying the water was within acceptable parameters. He had the lab report. He had signed statements from 14 families. He had a pediatric note from Maya's doctor flagging the chemical exposure as a plausible contributing factor to her ongoing gastrointestinal symptoms. He thought he had a case. The corporation's legal team filed a motion to dismiss inside 3 weeks. The argument was technical and precise. Briar Glen Municipal Water Services was a contracted management entity. It did not own the infrastructure. It did not own the source. Under the terms of its municipal contract, liability for contamination at the point of origin fell outside its scope of operations. Eli's lawyer explained it the way you explain something painful to someone who isn't going to take it well. "They're not wrong," she said. "We named the wrong company." The judge dismissed the case on procedural grounds, not on the merits. The judge was clear about that. This was not a ruling on whether the harm had occurred. It was a ruling that Eli had aimed at the wrong target. He sat in the parking lot outside the courthouse for 22 minutes. He didn't call Carmen. He didn't call his lawyer. He just sat there. That should have been the end of it. For most people, it would have been. 11 days after the dismissal, a routine insurance renewal packet arrived in the mail. Eli almost threw it away. It was the kind of envelope you open over the sink while you're thinking about something else. But something made him sit down with it. It was a liability disclosure form, standard boilerplate, the kind insurers send every year to update coverage terms. But on page 4, in a paragraph about additional insured parties, there was a line that referenced the water system's backup infrastructure policy. The additional insured party was listed as Caldwell Industrial Processing, the factory on Route 9, the one that had been operating outside Briar Glen since 1978, the one that employed roughly 1,400 people, the one that sponsored the Little League, donated to the school supply drive, and whose name was on a plaque outside the community center. Eli read the line 3 times. Then he called his lawyer. "Why," he asked, "would the town's water liability policy list a private manufacturing company as an additional insured party?" Pause on the other end of the line. "That," his lawyer said, "is a very good question." They refiled. This time against the correct architecture, the Municipal Water Authority, the contracted management company, and Caldwell Industrial Processing, named as a third-party contributor pending discovery. It took 6 weeks. It cost Eli $4,000 he borrowed from his father-in-law. Discovery is a legal process that sounds dry until you understand what it actually means. It means the other side has to give you their documents, their internal communications, their testing records, their maintenance logs. It means if there's something buried, you now have the legal right to dig. Caldwell's legal team fought the discovery request hard. 3 separate motions to limit scope, 2 requests for protective orders. Every delay tactic that money could buy, applied systematically and without apology. But they couldn't stop all of it. The first crack came in a deposition with a mid-level operations manager at Caldwell. His name doesn't matter. What matters is what he said when Eli's lawyer asked why there were no internal records of water quality tests conducted near the plant's drainage runoff points between 2014 and 2019. He paused, looked at his own attorney, then said quietly that staff had been instructed not to document anomalies during that period. Instructed not to document anomalies. Eli's lawyer put her pen down very slowly. What came next was a document dump, 1,700 pages of internal records, emails, contractor agreements, and maintenance logs, most of which Caldwell had fought to suppress and lost. Eli and his lawyer spent 3 weeks going through them. They brought in an environmental consultant. They cross-referenced dates. What they found wasn't a smoking gun. It was something more methodical. A pattern assembled across years of decisions made to prioritize containment over correction. There were internal test results that showed trichloroethylene levels near the plant's secondary drainage system running at 3 to 4 times safe thresholds as far back as 2011. There were emails between plant managers and the contracted water authority discussing temporary containment protocols that had, according to the maintenance logs, never been made permanent. There was language in a contractor agreement that shifted responsibility for incidental chemical migration from the plant to a subsidiary company that had been dissolved in 2016, a company that no longer existed. That couldn't be sued. That had quietly absorbed liability and then disappeared. Carmen asked him one night after Maya was asleep how close they were. Eli said they were close. She nodded slowly and then said, "If you win, what happens to the factory?" He didn't answer right away, because he'd been thinking about it too. 1,400 jobs, maybe more, counting suppliers and contractors. A paycheck that, in one form or another, touched nearly half the households in Briar Glen. He said he didn't know. She said, "I think you do." The documents never leaked the way Eli intended. He'd planned to let the legal process run, file, settle, or litigate. Let the system do its work quietly and specifically. But someone inside the case, identity still disputed, passed a summary of the discovery findings to a regional news outlet. The story ran on a Tuesday morning. By Tuesday afternoon, Briar Glen had fractured down the middle. The families with sick kids shared the article with fury in their captions. Former patients, neighbors who'd moved away, people who'd assumed their own symptoms years ago had just been getting older. They all surfaced at once. The comments filled with the specific grief of people who'd been told they were overreacting and now had proof they weren't. By Wednesday morning, Caldwell Industrial Processing announced it was suspending operations, pending an internal review. Workers were told to stay home, paid for now, but for now has a weight to it that everyone understands. The phones started ringing at Eli's house. Some calls were support, gratitude even, but more of them were not. A man who'd worked at Caldwell for 22 years called and said, "You just killed my retirement." He didn't yell. He just said it, flatly, and hung up. Maya came home from school with a note from her teacher. A boy in her class had told her that her dad was trying to make everyone poor. The teacher had intervened, but the note made clear that this was not an isolated incident. Carmen stopped going to her book club, not because anyone had said anything directly, because she could feel what was happening in the silences, in the way conversations shifted when she entered a room. Eli had become, simultaneously, a hero and a villain, and the two identities had no interest in coexisting. The settlement offer came through his lawyer on a Friday evening. It was a significant number, enough to cover Maya's medical bills, future monitoring costs, and what the letter described as additional compensatory damages. There was also, attached as Exhibit A, a non-disclosure agreement. The NDA was comprehensive. It covered all documents obtained in discovery. It covered the internal emails. It covered the contractor agreements, the suppressed test results, the maintenance logs. It covered the name of the operations manager who had said the words "instructed not to document anomalies" in a recorded deposition. It covered everything. In exchange, Caldwell would commit to a procedural review of its water management practices, not an admission of liability, not a public disclosure, a review to be conducted internally, results to be shared with the municipal water authority at Caldwell's discretion. Meanwhile, the real cost was spreading through the town like water finds its own level. A landlord on the north side of town sent eviction notices to 3 families because he had lost 2 commercial tenants who had depended on Caldwell contracts. The pharmacy on Main Street put a sign in the window saying it was reducing hours. A woman named Deborah, who ran the daycare center adjacent to the factory supply road, told a local reporter she didn't know if she could keep the lights on past March. These weren't abstract statistics. They were people Eli had grown up around, people whose kids had been in the same classrooms as Maya, people who hadn't made the decisions that poisoned the water, people who were bleeding for it anyway. Carmen sat down with him on a Sunday night, kids in bed, house quiet. She put her hands flat on the table. She said, "Sign the NDA, Eli. Take care of our family. Because if you don't, you're choosing other people's suffering over ours. And you can call that moral if you want. But Maya still has to go to that school." He understood her. He didn't argue with her. He loved her, and he understood every word she said. And then his lawyer sent him one more document. It had been extracted late, flagged deep in the discovery dump. misfiled under a contractor correspondence folder. It was an internal email, dated 2018, from a senior Caldwell executive to the company's legal department. It was 6 sentences long. The relevant part read, "In the event of regulatory inquiry, primary documentation responsibility should route through the municipal services contract. This ensures any resulting liability attaches to the contracted entity rather than to Caldwell directly. Planned, deliberate, written down, sent, archived. Not an accident, not negligence in the fog of a complicated system. A strategy. They'd built the plumbing of responsibility the way you'd build a fire escape, designed to carry weight away from the building towards something expendable. If he signed the NDA, that email stayed buried. The strategy worked, and somewhere else, another town, another contractor, another set of families with stomach aches they'd been told not to worry about, it could happen again. He didn't make a speech. He didn't call a press conference. He told his lawyer he wanted the email released through proper legal channels, filed as part of the public record in a parallel regulatory complaint. Not to a reporter, not for clicks. Filed formally, where it would have to be seen by the people whose job it was to act on it. He did not sign the NDA. The fallout was not clean. It never is. The State Environmental Agency opened a formal investigation into Caldwell Industrial Processing within 2 weeks of the regulatory filing. The municipal water authority's contracted management company settled separately and quietly. The plant did not immediately close, but it shed 400 jobs in the first 90 days as contracts were suspended and investors withdrew. The remaining workforce spent months in the particular purgatory of not knowing. The water remediation program was announced 4 months after the filing. The fix, which included infrastructure upgrades, new filtration, and independent monitoring, had been technically possible for years. It happened only because hiding was no longer possible. That's not the same as justice, but it's what the families got. Maya's symptoms improved, slowly, measurably. Her doctor noted reduced markers at her 6-month follow-up. Eli and Carmen separated in the spring. It wasn't loud, it wasn't bitter in the way movies make it look. It was quiet and sad and honest. She moved 40 minutes away, closer to the hospital where she worked. The kids went back and forth. Eli stayed in Briar Glen, which took its own kind of stubbornness. He wasn't celebrated. The families whose kids got healthier were grateful, but gratitude and celebration aren't the same thing, and Briar Glen was still a town where 1,400 people had spent a year afraid. That fear needed somewhere to go. Some of it landed on Caldwell's executives, whose names and emails were now public. Some of it landed on Eli. He kept doing HVAC work. He sat on a community water oversight committee that formed in the aftermath, 8 residents meeting monthly, reviewing test results. It was unglamorous and necessary. He said once to his lawyer that he wasn't sure he'd made the right call, not about the truth itself, about the timing, about whether there was a version of this where fewer innocent people got caught in the current. She told him she didn't think that version existed, that the system was designed to make that calculus impossible, that the choice was never really between a clean path and a messy one. It was between a mess now and a different mess later, somewhere else, to someone else. He said he wasn't sure that made him feel better. She said it wasn't supposed to. Truth has a body count. Not always the guilty ones. That's the part we don't talk about when we tell stories about people who did the right thing. We skip past the names of the people who weren't guilty of anything except living in the wrong town, working at the wrong plant, trusting a system that had quietly made them expendable. Eli Navarro didn't save Briar Glen. He didn't destroy it either. He found a document that changed what the town knew about itself, and then he had to live with what that knowledge cost. The water is cleaner. The factory is smaller. The Main Street pharmacy closed in November. There is no version of this story where everyone wins. There is only the question of who you're willing to let lose and whether you can live with the answer you chose. If you found this story worth sitting with, hit subscribe. There are more stories like this one, complicated, real, and not easy to shake.